Right. Good afternoon. This is the regularly scheduled meeting of the Public Safety, Civil Rights, and Emergency Management Committee meeting. Today is November 29th, 2017. I am Councilmember Blong Yang. I'm the chair of this committee. With me today are Councilmembers Reich, Palmisano, Gordon, Quincy, and Council President Johnson. We have a full complement of this committee, and so we can conduct the business of this committee. Today we have several items and several consent items and then several public hearings. I will read off the consent items first, and then we'll address the public hearing piece next. And I have one item that I'm going to change, which is the receive and file, which is item number 10, and we will just put that on the consent item so that we don't necessarily need to do the presentation for that. We'll just receive that. So with that, I will read the consent items. Item number 1 is a contract amendment with Translanguages, LLC for translation and interpretation services. Item 2 is a grant from the Minnesota Homeland Security and Emergency Management for the Police Bomb Disposal Unit services. Item 3 is a joint powers agreement for participation in the Minnesota Bureau of Criminal Apprehension Human Trafficking Investigators Task Force. Item 4 is a contract amendment with Foresight Consulting Services, LLC for tabletop services and after-action reporting. And item number 5, which is actually item number 10, is to receive and file the 2017 third quarter report, Contract Compliance Division. Council members, anyone want to pull anything off for discussion? Okay, seeing none, all those in favor, please say aye. Aye. Any opposed? Okay, the motion carries. All right, we will now get to our public hearing or hearings. There are, let's see, there are 5 public hearings today. The first one is appointments to the Police Conduct Oversight Commission. The second is appointments to the Minneapolis Commission on Civil Rights. The third item is a civil rights ordinance. The fourth item is amendments to the Police Conduct Oversight Ordinance, and the fifth item is an unmanned aircraft ordinance. And so we will start with the first one, which is appointments to the Police Conduct Oversight Commission. And the staff member here to present, please go ahead.
Chair Yang, Council President Johnson, members of the committee, my name is Imani Jafar. I'm the Director of the Office of Police Conduct Review, and today we're putting forward a slate of candidates to be approved by you for the Police Conduct Oversight Commission. You can see the candidates here on the slide. All of them are reappointments with the exception of Kate Bischoff, who is here if you'd like to ask her or myself any questions.
Okay. Council members, any questions? All right, seeing none, I will open up the public hearing, and anyone who wants to speak can come up. And I don't imagine we have a long list of folks, and so I'm not going to ask you to sign up with the clerk at this point. Anybody who wants to speak during the public hearing, please come on up. We'll give you 3 minutes, and we'll kind of go from there. And if you can introduce yourself, give us your address or something identifying, that would be wonderful.
Mr. Chair, committee members, Chuck Turchik, 2112 Portland Avenue South. I have a comment about the process. I'm sure all of these applicants are well qualified, but I do have a comment about the process, a suggestion, and one observation. Someone sent me an email that was available on the Minneapolis city website from a comment that someone made a year ago when there were a similar appointment hearing. And I thought it made some sense, so I'd like to read it. It's very short. It came from someone named Chuck Turchik. It was dated November 25th, 2016. Dear Public Safety, Civil Rights, and Emergency Management Committee. It seems we go through this every time you hold a, quote, public hearing on appointments to the Public Conduct Oversight Commission, the Police Conduct Oversight Commission, the Police Conduct Review Panel, and the Civil Rights Commission. Once again, your agenda provides no links to the publicly available information about the appointees. Why in heaven's name do you invite the public to a public hearing When the public knows nothing about the appointees other than the wards they live in, why do you waste money on such a hearing? Why don't you amend the charter or ordinances or rules that require such sham hearings? I don't expect to live to see the day, but one of these years, maybe we can get a city council that takes these public hearings a little more seriously. Yours for real transparency, Chuck Turchick. I renew that email this year. My suggestion is that for those of us who made data practices requests to get the public portion of the applications for the people who were appointed and the unsuccessful applicants, the material that we receive has to do with their background related to any required desirable qualification listed in the notice. My suggestion would be, since these applicants are asked during their interviews, why not include a question on the form specific to the PCOC, for example, like, what do you think the PCOC should do? Do you have an interest in any particular projects you think they should be engaged in? How do you see the role of the PCOC? For the public to have access to that kind of information, it would be very valuable. And my observation is that I'm looking on the publicly available portions of the applications, and I noticed for the unsuccessful applicants, these are their occupations: social worker, writer, editor, manufacturing, attorney, guest relations supervisor, senior recruiter and founder, CEO, human services professional, product manager, and student. These are the 5 successful applicants, their occupations: attorney, employment attorney, human rights consultant, lawyer, attorney, and attorney criminal defense. All 5 of the successful applicants, attorneys, is not required in the ordinance. One of the 9 unsuccessful applicants is an attorney. I think that's skewed a little bit heavy in favor of the attorneys. Thank you very much.
Thank you. Are there any other speakers?
Yes, thank you. I'm Dave Bicking, 4200 Cedar Avenue in Minneapolis. I second Chuck's comments. Again, it's very hard to comment on applicants when we don't get that information. Fortunately, Chuck forwarded that information to me, so I have at least a little bit to go on in order to comment on the new PCOC members and the reappointments, of course. Chuck and myself and Jan and a few people have followed the PCOC quite regularly and can form some, opinions based on that. Yeah, so there's little known about these people. I do have a concern. One of my concerns was the same as Chuck's, that of 5 people being appointed, 5 of them are attorneys. This seems to be more than coincidence, more than what would be representative of the Minneapolis population. For a citizen commission, these are not supposed to be necessarily professionals or professionals related to this particular field, but people, more representative of the community. And we're not seeing that. Of the 2 who remain, I don't know one's occupation and the other one is not an attorney, but he's currently working for a law firm. So that's 6 people in that field. So that's one of my concerns with the appointment of Kate Bischoff, who I don't know, and I can't really form an opinion of her as a person. But I do have a few concerns about her background, other than her being an attorney. She is an attorney who works exclusively for employers in human resources. Now, that means that she, sets policies, and that's a good thing related to this. Hopefully sets policies that avoid liability. That's a good thing. But being an attorney representing human relations for employers, she is also the person who defends the employer whenever there is a lawsuit regarding the actions of one of the employees. In particular, she spent 3 years with the State Department, both in Jerusalem and Zambia, as a human resources person, including, as she says on her application, for people who are armed security guards. And so it was her business to make sure that, you know, those armed security guards that did the proper thing, but I'm sure it was also her business to defend them in other situations. It would be extremely similar to the function of the Internal Affairs Unit in the Minneapolis Police Department. Also, since she's only worked for employers, in this case, the employer is the Minneapolis Police Department. Regardless of her qualifications and her opinions, which I have no idea what they are, I might think very highly of her, but that seems to be something that's not really appropriate for a citizen board of commissioners who are, you know, dealing with the issues and problems of the Minneapolis Police Department. There are some other, I think, very highly qualified candidates. One that struck me was Emily Matthews, who's a social worker and has worked in the mental health field and has worked with officers when there's mental health emergencies. That's something the PCOC is currently working on, and I think would be a very good background. There are other choices, and as I say, nothing personally against Ms. Bischoff, but it seems inappropriate to me. Thank you.
Anybody else wanting to make public comments during this public hearing? Going once, going twice. We will close this public hearing. Thank you. With that, I will just move the appointments of the Police Conduct Oversight Commission. Any discussion on any of those appointments? Right, seeing none, all those in favor, please say aye. Aye. Any opposed? Motion carries. All right, we will move to the next public hearing, which is an appointment to the Minneapolis Commission on Civil Rights.
Chair Yang, Council President Johnson, Council Committee members, my name is Danielle Shelton Volchak, and I'm the Director of the Complaint Investigations Division for the for the Civil Rights Commission, or the Civil Rights Department. And today, on behalf of the department, we are requesting confirmation of the following new and returning commissioners. Aaron Cornfield, Aaliyah Hodge, Miriam Mokri, Katie Armendariz, Alfonso Cornish, Brian Malloy, Anika Robinson, Paul Herkman, David Farrar, Donna Majarian, Dominique Jones, Cindy Lord, Jennifer Truian, Shania Turner-Smith, and Elizabeth Simons. And I'm happy to stand for questions if you have any.
Okay. Anyone have any questions? Right. No questions. We will open up this public hearing. Anybody wishing to make any comments, please step forward.
Thank you. My name is Amy Berquist. I live in Ward 3 at 700 South 2nd Street, and I am currently serving on the Commission on Civil Rights as an attorney member of the Commission. I was appointed in July 2014. I am here in my individual capacity. I'm not speaking on behalf of the Commission, and I'll also note that I am an interested party. I applied for reappointment, and the department did not select me on its roster. I've submitted written comments to the committee this morning, and I believe they've been provided to you as well in hard copy. My first concern is that the department's proposed slate of commissioners seems not to be in compliance with the ordinance in two respects. First, the ordinance sets a commission consisting of 21 members. The department seems to have elected to leave two seats, seats 11 and 14, vacant, while the department's report to the committee says that 39 Minneapolis residents applied. So there are two vacancies that the department has elected to remain vacant. And second, it seems that only 3 attorneys will be serving on the commission as of January 2018. The ordinance requires a minimum of 6 and a maximum of 8 attorneys to serve on the commission. The commission, I will note, also started 2017 not in compliance with the ordinance in both of these respects. We started 2017 with only 14 commissioners out of 21 seats, and we had only 5 attorneys, not the minimum of 6 in 2014. Now we have 4 attorneys because one of those attorneys is no longer on the commission, and only 2 of those attorneys will be continuing next year. This points to an additional need for transparency from the department in its reports to this committee. The report from the department at this time last year noted that some new appointees were filling vacant seats while others were replacing commissioners, quote, who chose not to reapply. There's no similar notation this year, nor is there any notation that 2 commissioners had reapplied, including myself, but had not been selected. Also, with respect to the attorney requirement, reports from the department to this committee at this time in 2014, 2015, and 2016 included an attorney notation for people who were attorneys, but there's no such notation in this year's report. And it makes it difficult for the city council and for this body to determine whether the slate of proposed commissioners is in compliance with the ordinance. Thank you for your attention.
Thank you. Any other speakers?
Dave Picking, again, 4200 Cedar Avenue. Yes, this is a commission that I have not followed nearly as closely as the ones more directly associated with policing. But at one time, the Commission on Civil Rights was a very good place for people to take a complaint of discrimination by the police when they didn't have enough to have a full-blown lawsuit or whatever, and people could get some compensation. And I know that happens sometimes. I've witnessed one case that was like that. But under your watch and the watch of the Director of Civil Rights, Velma Carbone, the Civil Rights Commission seems to be falling apart. I say this somewhat as an outsider, so I don't know the full details of how this goes. I have mostly what's on the website to go by. But yes, for the past year, and I've checked occasionally, for the past year, there have been 7 vacant seats out of 21. That's pretty outrageous. And to leave a couple of vacancies now while there are still qualified people, I think indicates a lack of interest or a desire to control the commission by only appointing certain of the right people. The lack of lawyers also I noted as well, and I think that's very important. But here's something right on the website of the Civil Rights Commission. It says that, yes, the commission is comprised of 21 Minneapolis residents whose primary function as a commissioner is to serve on administrative hearing panels that decide discrimination cases. The panels consist of 3 commissioners. One of them at least has to be a lawyer, which is obviously where you get the requirement that 6 to 8 out of the 21 should be lawyers. So that's the primary function it says here. Also on another page of the Civil Rights Commission website, it says, on December 4th, 2014, and this is a page that's currently up, so we assume that this is still the case. On December 4th, 2014, almost 3 years ago, the Commission on Civil Rights held its first contested case hearing in over 5 years. Remember, this is the primary function of the commissioners. So that means, given the date now, that means there has been 1 contested case hearing in 8 years. This has happened under the watch of this committee, of the director of the Civil Rights Department. Does anybody care about this? I mean, I noticed it because I look occasionally at the pages of the Civil Rights Department. But boy, if this is new news to you folks, there is something seriously, seriously wrong here. And I'm afraid the Commission on Civil Rights has been allowed to basically disintegrate. I look at some of their meeting minutes, and to be honest, it seems like the biggest thing that they do at their meetings is to run the annual Martin Luther King students essay contest. Most of the committees don't meet because they don't have quorum. It's a shambles. And I think we need a better commitment to civil rights than that. I wish I could knew more and more of the specifics, but I think it's really time for people to look into that. Thank you.
Do we have any other speakers?
Mr. Chair, committee members, Chuck Turchik, 2112 Portland Avenue, South Minneapolis. I had no intention of speaking in this portion of the hearings. I know nothing about the Civil Rights Commission. But if there's a shortage of attorneys on the Civil Rights Commission and there's an excess of attorneys on the PCOC, I know where you can solve one problem. A second comment. I don't know Amy Berquist personally, but if Amy Berquist is not qualified to serve on the Civil Rights Commission of the city of Minneapolis, no one in this city is qualified to sit on that body. I'm familiar a little bit with her career. She was a teacher, then she became a lawyer and went on to serve as a clerk to U.S. Supreme Court Justice Ruth Bader Ginsburg. And it seems to me there must be something going on behind the scenes for her not to be reappointed to the Civil Rights Commission. I know that she has spoken out at public meetings. I have heard her speaking out on police conduct issues. I don't know if that's why she was not reappointed to this body, but if there is anyone who has been a diligent worker of the Civil Rights Commission more than Ms. Berquist, I would like you to tell me who it has been. Thank you.
Thank you. Any other speakers? Do we have any other speakers? Going once, going twice? Right, we will close the public hearing. There are a few things that are going to happen here, but let me start by just passing it over to Councilmember Gordon.
Thank you, Mr. Chair. What I wanted to do was amend the recommendation to approve the reappointment of Amy Berquist for seat 14. I believe it's for a 2-year term beginning January 1st, 2018, although I have to say that in Amy's note, it says seat 14 is a 3-year term. So I'll move my research that I came said a 2-year term beginning in January 1, but if staff wants to correct me if I'm wrong, and if there's a problem in the length of the terms, I certainly want to know about it. And that's, I guess, all that I wanted to do now, so at least we know that if this amendment passes, then we have the full slate to consider.
Okay. All right. Anyone want to speak on the amendment? Council President Johnson.
Thank you, Mr. Chair. I guess I would ask staff to respond to the, several things that were brought up. And I would just ask for some background. Who was the review committee for these 39 applicants, and how was it determined who would be recommended for reappointment and new appointments and that sort of thing? And then I think it is important to address, Ms. Berquist talks about in her letter about the lack of quorum at meetings and vacancies and so on. And I will just say to Mr. Bicking, I remember times when we've had more vacancies than this over the years. So this is not brand new, I guess is what I want to say. But it is important, and so I think it would be helpful to have staff respond.
Chair Yang, Council President Johnson, to answer some of your questions. So when we were undergoing interviews today, we had, it was myself, it was a former member of the commission who has since joined the department, and it was our equity division director who is also part of that. We also sent out invites to all of the council members to attend those interviews, and unfortunately, I think your schedules did not permit you being a part of that. And then secondly, we look at a myriad of things when we are looking at reappointments and new appointments. We look at experience, but that's not a deciding factor. We look at desire. We look at transferable skills. We look at collaboration, and we look at all of those things on top of, with returning commissioners, we ask about their activity level. Particularly in this year, we asked about the activity level of going out to community. we have a lot of issues that a lot of community are facing a lot of civil rights issues, in particular with the new administration overall at the federal level. And so when we were talking to reappointed commissioners, we asked them to kind of go through their activity level and going out to community, connecting with them, their availability to do so, not only in the past year, but over their tenure overall. And then we actually look at years on the commission. We know that that we always want to have a diversity of thought on the commission. And sometimes there are commissioners who have been on for an extended period of time, and we want new ideas and new thought processes. And we also want to make sure that we have a diversity of people also in experience level, where they come from, and also in race, color, creed, religion, etc. So those are the things that we looked at, and then we assess, given the totality of all those things, how they're answered by the applicants, whether we think that they would be good commissioners. I hope I've answered your question.
Yes.
Chairman, can I just follow up? The issue of vacancies on the commission and whether we have enough people on the commission so that we haven't had quorum issues.
Yes. So let me talk about that a little bit. That has been a real big concern of ours. There is currently an absence policy that was in the Minneapolis Civil Rights Ordinance that spoke to the fact that if commissioners were not present at 4 meetings throughout a calendar year, that they would be let go from the commission. That was put in place specifically to make sure that if you're going to be involved in a body in which we are trying to forward the ideas of civil rights within the community, you should be present during the majority of the meetings. And unfortunately, what happened is a lot of commissioners were not present. And so they were, based on the ordinance, they were taken off the committee. I will say that there is a process in getting new commissioners. It's not as if we, as a department, just try to go out and say there's ongoing application, there's a whole process we get through, obviously coming in front of this body, asking for approval and things like that. The absentee and the lack of commissioners has been a tremendous concern to us, tremendous. We were looking for commissioners, and what has also been a tremendous concern, quite frankly, is the fact that we want commissioners who are able to go out to community to address those civil rights issues, come back and figure out how we can have an impact, not only just on the commission and the department, but maybe even more collaboratively. And so when we were picking commissioners this year, we feel that it is rebuilding, and we do take civil rights extremely, extremely seriously in our department. And so when we were building the Civil Rights Commissioner, putting the slate forward, I should say, we were looking to all of those things.
Okay. One other thing, Mr. Chair, if I might. The issue of having enough attorneys on the panel. That was the other thing that was brought up, and I'd forgotten.
Yes. So we believe that we did have enough attorneys on the panel going forward. That could happen in oversight on our end. We always are. We particularly try to get attorneys to be on the commission, assuming that we take into consideration all the things that I've talked about earlier. And quite frankly, attorneys they're very time strapped in getting onto the commission. But we have no intention on shirking the responsibility or the requirement of having attorneys on the commission.
Okay, thanks.
Yes, thank you.
Any other questions? Right.
I don't really have
Gordon.
a question, but I just have a comment. I really appreciate that the panel and the group and the process that went through, and my effort to change it now wasn't necessarily to say that work wasn't satisfactory. I also regret that I couldn't be part of it. In previous years, actually, I've been part of the review panels, and I suspect if I'd been there, I could have been doing the reviews with all of the other group who was there, and maybe we would have come up with this fix before now. So I apologize, but I also think it's just the role of our committee to review it and look at it. I'm very interested in trying to have as full a slate as we can. I understand there'll still be one more vacancy, so that's all right. And I think I just didn't want anyone to feel like I was somehow slighting the work that had done, and I wish I could have been in the review panels. So.
Okay. Any other discussion on Councilmember Gordon's amendment? Right. Seeing none.
Chair, may I add something, please?
Please.
And I did want to address one thing when we're talking about the quorum issues that were brought up. We have once in the proposed Title VII ordinance amendments attempted to change that because the quorum has been set at a specific number. In keeping in practice with other boards and commissions and things like that, we've sought to change it to a majority of the commissioners, so we can continue to conduct business, and if this happens again, not have those quorum issues.
Council President Johnson.
So a majority of the currently serving, or how you define
So
it?
the majority of currently serving commissioners. So as the ordinance was originally written back in decades and decades ago,
40s?
it was 9 solid. And so when we have the turnover of commissioners who are not attending on a regular basis,
And it hasn't been filled.
right, then the 9 quorum can't be met. And so to keep pace with what's actually happening in, like I said, boards and commissions currently, not only in the city, but in other places, that it's the majority of active commissioners.
Could I?
Mr. Chair, can I
Yep.
just, I'm not going to support this motion today. I'm sorry, Ms. Buck, but I have to say I respect the process, and I know that there can be challenges in some of the dynamics that happen in a committee of people, and so I don't know Ms. Berquist, but I'm not going to be supporting this motion today. I think if anything, we should go back and look at open the process again or something like that and review.
I have a question with regards to this attorney issue. When folks submit their applications, I mean, do we take them at the word that they're attorneys, or are we checking to see if they have a license, or what's the situation? I mean, what type of background do we do on folks just so that we can confirm that they're attorneys?
Yeah, we do confirm that they are attorneys, and it's an easy lookup. Quite frankly, you can do it online. So we do confirm that. And the attorney community is fairly small too. So having been a practicing attorney for a long time, we run across people that I know also. So
Okay.
yeah.
Okay. All right. Any other comments, questions? All right. Seeing none, the motion before us is to approve the following council reappointment for a 2-year term beginning January 1st, 2018 and ending December 31st, 2019. And the name being put forward by Councilmember Gordon is Amy Berquist for seat 14, Ward 3. All those in favor, please say aye. Aye. Any opposed? Okay. The ayes have it. Motion carries. And we will go to item number 6 as a whole. So it's a slate. And I'm gonna put 2 staff directions in after we take this vote, but I think it's appropriate to just do it afterwards. And so, item number 6 as a whole. Anybody have any comments or questions with regard to that? Okay, all those in favor, please say aye. Aye. Any opposed? Okay, the motion carries. I have 2 staff directions related to these 2 prior public hearings. The one on the Police Conduct Oversight Commission and the Minneapolis Commission on Civil Rights. And the first one is, I sent it, since I'm chairing, I apologize, I sent it to you all via email. The first one is directing staff to provide accessibility to all applicants' publicly available information when publishing agendas for public hearings, considering appointments to both the Police Conduct Oversight Committee and the Commission on Civil Rights, but I mean any of these other appointments through the Civil Rights Department. And I'm going to speak on that really quickly. I just think that when we have public hearings, I mean, if you don't know anything about the folks that we're appointing, I mean, I think to Mr. Turchick's point, I mean, why do we even have a public hearing? I mean, we have to at least know what people's qualifications are to, really speak on them, or to have a way of digesting their qualifications or who they are before we can, move forward with this. And so I think, it's appropriate to have links to the qualifications or resumes or something like that to help all of us, council members included, in making these appointments. And, I just checked with the city attorney who staffs our committee, and, I don't think there are any prohibitions against that necessarily. And I think it's important to at least have that so that we can actually have public hearings that mean something. And so those are my comments. Any other comments, Councilmember Gordon?
I support this.
Anyone else? Okay. All those in favor of the first staff direction, please say aye.
Aye.
Any opposed? Okay, and the next one is staff direction directing the city attorney's office to review the compliance of the membership of both the Police Conduct Oversight Committee and Commission on Civil Rights. And, I think to that point, I think it's just important that, as a committee, I mean, we take our responsibilities seriously to look at these sorts of things. I don't think anybody up here has the time to really go look at the ordinance and, look at every single thing and see if the requirements are met for specific members and all that stuff. And I think it's important for the city attorney's office to take a look at that. It might be fairly easy for them to do that, but I mean, it helps us to at least be doing this right so that these meetings that are happening actually meet the quorums, actually follow the rules, actually have the appropriate number of attorneys. I mean, any number of those sorts of things. And so I'm asking for your support on that. Councilmember Quincy.
Thank you, Mr. Chair. I wondered if you could repeat the first line of that staff direction.
Yeah, directing the city attorney's office to review the compliance of the membership of both the Police Conduct Oversight Committee and the Commission on Civil Rights.
Okay. I fully support the staff direction. I wondered if we might want to consider adding some language that said make any recommendations as appropriate, as well as put a timeline on this to come back to this committee at some certain point.
Okay.
I don't know what that would be. That's up to you as the author, but I thought I would add those. I think those are two components of the staff direction that are more helpful.
Okay. Council President Johnson.
Thank you, Mr. Chair. I'm just wondering if part of our process and procedure is hampering the ability to fill vacancies when we have these deadlines or only a couple times a year where we have openings. Do you know what I'm saying? We had that review of how we did our open appointments process, and I'm just wondering if we've handicapped you by requiring time frames for appointments.
Mr. Chair, Council President, and committee members, my name is Velma Carbone. I'm the Director in the Department of Civil Rights. You're right, Council President. The process that we use is the process that is administered by the clerk's office.
Right.
So I don't know if all the committee knows that, and certainly for people behind me, but so the process that we use, the way the item is formatted when it comes to the city council, the information that's there, that is all part of the clerk's process. So we are following that clerk's process. With regard to whether or not the timing, if that's hampering our ability to do work, the clerk has also been very flexible with us, is that if we want to come back, there are two appointment cycles that we have an opportunity to piggyback on. The one is this end of the year cycle that we're on right now, and then there's also a cycle that happens in the summer.
Okay.
And so one of the ways that we typically fill vacancies that exist on the slate at the end of the year is to continue to recruit for those positions and then come back in a summer term. So the two positions, now one position that we had left open was specifically to continue to recruit attorneys to move into those roles. So with regard to hampering the work, two other things that I would say. There's a difference between the contested case hearing and the administrative hearings that these attorneys are sitting on. The administrative hearings for appeals is a more time-intensive, it's a more regularly recurring thing, and that happens on an ongoing basis. And so this notion that we are only having contested case hearings or attorneys are only being utilized every 8 years. I'd also like to correct that for the committee. Attorneys are utilized in this work on an ongoing basis. The contested case hearings, for folks who may not know what that is very much like a trial. The format that it takes is very much like a trial. If you go onto the website and look at the picture that's on the website about the contested case hearing that happened in 2014, you will see it took place over at the University of Minnesota. It's set up just like a trial, and the commissioners act like that panel of jurors. So it is. I just want to talk a little bit about what the way the work is structured, so people understand how those attorneys are used. And the other thing that Ms. Shelton Volchek said is that attorneys are very busy, and the work that they do on the Civil Rights Commission is very intensive, because when we send a case to them, they're reviewing files, they're reviewing evidence, they're reviewing materials, they're writing summaries. It's a lot of work for them. So it's understandable when we get attorneys onto the commission that they stay for a little while and go, you know what, I got my regular job. I need to be doing all the same things. You know, volunteering is supposed to fill my bucket, not, take away from the things that I want to do as a volunteer. So it is a very labor intensive volunteer role that they do. So I just wanted to make sure that people know sort of the structure and the distinction between the contested case hearing and the administrative hearings that we do. It's a lot.
Very helpful. Thank you.
Thank you. Any other questions and comments regarding this second staff direction? And Councilmember Quincy, I'm going to make the amendment that reads in part, directing the City Attorney's Office to review the compliance of the membership of both the Police Conduct Oversight Committee and the Commission on Civil Rights, and this is the new stuff, and make recommendations as needed. The City Attorney's Office shall report back to this committee by the end of February 2018. Okay, thank you. Should I ask for a vote on that amendment? Okay. Okay, all those in favor of the amendments, please say aye. 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 Okay, any opposed? And then we will vote on the staff direction. All those in favor of the staff direction, please say aye.
Aye.
Aye. Any opposed? Motion carries. Thank you so much. And again, my apologies for maybe breaking with the way we usually do things by just not casting out a staff direction, running the meeting while doing this. So thank you. Appreciate that. All right, we will move on to the next public hearing, and that is the Civil Rights Ordinance, and it's a passage of the ordinance amending Title VII of the Minneapolis Code of Ordinances related to civil rights, updating the Civil Rights Ordinance. And the staff member who is going to do that, please step up. Please go ahead.
Chair Yang, Council President Johnson, Council Committee members, once again, I'm Danielle Shelton. I'm the Director of the Complaint Investigations Division of the Civil Rights Office. And along with my colleague, Sean Skippy, who is the Director of the Contract Compliance Division, we will be giving a very brief overview of the proposed Title VII amendments. So since 1967, the Title VII has had a variety of changes, but what has not happened is actually a full comprehensive update of Title VII. So when we were going about doing this task of updating it, we had four objectives in mind. We wanted to create more clarity and readability for anyone reading the ordinance. We wanted to update its nomenclature. We were attempting to make the ordinance provisions consistent not only with department practices, but also with the Minnesota Department of Human Rights and any federal and state statutes and case law. And we were attempting to create accountability in the areas of equity, specifically in Section 139.50, which governs contract compliance. So as an example of clarity and readability, jurisdictional elements, so basically the jurisdictional requirements of bringing a claim within the department in an investigation, were spread all across the ordinance. So what we did is we took all of those components, we put them at the top of the ordinance under 139.110. We created a jurisdictional section, so someone coming into the ordinance would see all the jurisdictional requirements in bringing a claim with the department. We also wanted to update the nomenclature, quite frankly, and make it acceptable and appropriate for normal cultural parlance. So first of all, we deleted what was offensive terms such as ghettos in 139.10. We also wanted to update legal language too. And so we deleted the definition of reprisal as an example. We substituted it out with the current language that's used for cases, which is retaliation in particularly the employment context. And now that's consistent with federal and state statutes and case law. And then we also wanted to update the ordinance with other nomenclature, such as disabled persons. We took that out. That is not the appropriate term any longer. And we made it consistent with the Americans with Disabilities Act, and we now have persons with disabilities, and we made all those corrections throughout the ordinance.
Council President Johnson.
Mr. Chair, thank you. And Ms. Walczak, so what, and unfortunately I don't have the current language in front of me, so what did we replace terms and references to ghettos, the title? So what, did we just eliminate that entirely?
We eliminated it. We made because the definition, the policy and purpose is fairly set out. So the elimination of ghettos does not change the overall policy and purpose of the ordinance. I mean, it still stands as that the goal of the ordinance is to eliminate, in its general term, discrimination.
Okay, I actually thought that was always quite a useful term because I'm trying to think, I think Councilmember Samuels used it one time to talk about sex offender locations. So I'm a little nervous about saying that's, or eliminating that. I'd like to see it redefined or some different language, because I think we need to be specific about the city, not
Concentrating?
Yes. That is a huge issue. We have huge disparities. We have huge segregation in this city, and we need to be upfront about that that's not a policy that we can support. So that's going to be an issue for me.
I don't disagree with that. Sorry, Council President Johnson. I don't disagree with that at all.
Okay.
We had feedback from people on that terminology. Ghettos.
I don't like the word ghetto either. Don't get me wrong. But I guess what I'm saying is that that was a term that was used to describe a particular place in the city, or particular outcomes that you get when you have policies or whatever. But I think the philosophy behind the city not being supportive of some of the challenges that result from concentrations is something we need to be specific about in our ordinance.
Yes. Chair Yang, Council President Johnson, I think based on what you said, I think it's entirely possible to say as a policy and purpose is to eliminate the existence of concentration of something to that effect, minority concentration, or what have you in the community. I'm not sure, but
I just think it's a point to be considered.
Okay.
Not eliminating it entirely. The philosophy behind it.
Councilmember Reich.
Thank you. Not to wordsmith in committee, Mr. Chair, but I think the term that we have been using in a lot of other documents was racially concentrated area of poverty, RCAP, which is language that we borrowed from Met Council. However, our council has recently adopted new language to replace RCAP. So
Okay.
if you want jurisdictional consistency, you might want to consult that or use our own term that's located in other policies, which is RCAP.
Thank you for that.
You can go ahead.
Thank you. We also attempted to make the ordinance changes consistent with department practices, with the Minnesota Department of Human Rights and federal and state statutes. So for example, if you look at section 141.80, that is a section that articulates the director's powers and duties. And what we've added is adopt and publish such rules, regulations, forms, and guidance documents that are reasonably necessary to carry out the provisions of the title. This happens actually quite frequently when a new ordinance amendment comes within Title VII. So the perfect example is when we have the ordinance passage of safe and sick time, and I believe that there was a year gear up for that, and we just passed Section 8 earlier this year in 2017. And while we're doing gear ups before enforcement, that is usually a year long, this is exactly what we do, is to create those rules and regulation and guidance for those new title amendments. We also attempted to make the ordinance consistent with Minnesota Department of Human Rights and state and federal case law. So as an example, in the area of public service, we added the language, if someone that it is actually discriminatory conduct to fail to ensure physical and program access for, I put it, persons with disabilities, excuse me for that one, unless someone can show that it imposes an undue hardship. This language is consistent with the Minnesota Department of Human Rights. It's consistent with the Minnesota statutes also. And then when we were looking at the ordinance updates, the fourth objective was accountability. And so with that, I'm going to hand it over to my colleague, Sean Skippy, to talk about those changes in 139.50.
Thank you, Director Shelton Volchek. Mr. Chair, members of the committee, my name is Sean Skippy. I'm the Director of the Contract Compliance Division. As my colleague mentioned, there are several themes to the amendments of Chapter 139 before the committee today. One of them is updating the language and improving the readability of the ordinance. And Director Shelton Volchek just discussed a few of those. And the other theme to this ordinance update is accountability, specifically for contractors that do business with the city. That section is 139.50 primarily, and those are the changes I'm going to talk about today. The first change is right in 139.50 A1, the first paragraph, where the 40 to 70 caveat relating to age discrimination was eliminated. And we also added familial status as a protected class. The 40 to 70 caveat language was originally inserted to mirror federal requirements. So removing this mirrors changes made in other sections of this ordinance in Chapter 139.40, and including familial status here also mirrors the language of that section as well. The next change increases the maximum penalty for noncompliance while providing some added discretion to the department when applying these penalties. First, the mandate that the city withhold up to 15% of the total contract is instead changed to an option for the city to do so. This is important primarily because noncompliance determinations are very technical, fact-specific in nature, and having an all or nothing provision can make it more difficult for the department to actually utilize and apply in a fair way. The second change to this paragraph updates the maximum liquidated damages that can be applied for issues in noncompliance. Part of this is due to inflation. As my colleague mentioned, this provision has not been updated for quite some time. And we think this change is also important, though, because it raises the cap that can be applied to particularly bad actors. So the liquidated damages maximum goes from $500 per day to $1,000 per day. On the second slide, the first bullet point addresses a deadline put into place for the first time to resolve noncompliance issues. As the slide references, this is important because it establishes 90 days for the ordinance language that requires the department and the contractor to engage in conciliation or persuasion. This can result, without that timeline currently in place, can result in delays or a lack of urgency in resolving a compliance issue. And it also provides a clear timeline for the department to give the contractor before it can implement non-compliance measures. And then when the department does issue a non-compliance finding, the language has also been updated to provide clarity around the procedures to follow, allowing either the Civil Rights Department director or the contractor, through the director, to request a hearing before the Civil Rights Commission. The next change of note to the ordinance is explicitly creating authority for the department to audit affirmative action plans. This is already in the department's view implied in the ordinance language, but is important for several reasons to add explicitly. First, contractors hired by the city are often representing to the city to the public, either officially or unofficially, and this helps ensure these vendors are acting in accordance with the city's values of equity, diversity, and inclusion. And second, the Civil Rights Department has an expectation that it will complete pre-award review of contractors within 30 days because of the SUBP ordinance requiring it to do so. So the approval process for the AAP can actually be compressed, and the explicit authority clarifies, the explicit authority to audit clarifies that the department can review these AAPs it is already approved when it was doing so in an expedited process. And then finally, I want to address the last bullet point, an update to the reporting requirements for the department in the ordinance, requiring an annual report to the council instead of the quarterly report for the Contract Compliance Division. This change is being proposed for several reasons as well. First, projects can take a long time to construct and complete from the time of authorization of award to the completion of the contract. So reporting over longer periods of time can create a more accurate picture of the division's outcomes. Second, it takes significant division resources to produce and present this report every quarter. And then finally, and perhaps most importantly, this data is soon going to be available real time through a link to the Tableau reporting system that is available right on the department's website. And this will allow technology to be utilized to provide transparency directly to the public on the division's outcomes. And that concludes a summary of the changes to 139.50. I'd now like to turn it back over to my colleague, Director Shelton Volchek.
Mr. Skippy, if you can hold up for a little bit. This real-time reporting instead of the quarterly reports, I mean, tell me a little bit about the real-time reporting. I mean, is it going to be through some program that is accessible to anybody, basically?
Yeah, thank you, Mr. Chair. The link is going to be right on the Civil Rights website, and it's going to pull from the same spreadsheet that we pull from when we present the information to the committee. So it's going to be pulling the same data, and instead of having to assemble a report and edit everything, the system just does that directly, and that's one of the features of Tableau that the city's using in other departments already.
Okay. Councilmember Gordon?
I just have a question. You talked a little bit about the hearing when they're non-compliance. A hearing could be requested, and the Civil Rights Commission chairperson would appoint a 3-person panel. And then there's also the option of a hearing examiner. Was that in the old ordinance, or is that a new idea? So this is in 139.5. Down page 32, at the top of page 32. And I'm just wondering if this is a brand new idea, and if it isn't, did we rely on a hearing examiner often? And if it is a new idea, why are we going that route? Is it just so hard to get the panels together or something like that? I'm not even sure how many times we've ever had hearings either.
Thank you, Mr. Chair. Do you want to address that?
I can ask you answer
A
some of the
little bit,
preliminary
okay.
questions if you don't mind. So, Chair Yang, Councilmember Gordon. So the hearing examiner idea actually is new, and we added it to 13950 to make it consistent throughout the ordinance. But the hearing examiner, after consultation with the commission and the department, the Minneapolis Civil Rights Commission and the department, the acting chair of the commission can appoint a hearing examiner. The reason why we put the hearing examiner was for two reasons. One, the hearing examiner, they would more than likely have a very specialized expertise that might not be identified on the commission. And so it allowed for the leeway for both the commission and the department to decide on whether they wanted to bring in that specialized expertise. The second reason is that sometimes, and I think it might be in particular with contract compliance, but we wanted to give some leeway that we could bring in someone much more expediently than attempting to get a panel together, especially when time is of the essence, I know, for contract compliance issues. So we can bring in someone on a fairly quick basis to address those issues. But those aren't done, bringing in a hearing examiner is not done on an autonomous basis with just the director. It's in conjunction and consultation between the commission chair and the director.
And the way I read it, it's almost the chairperson of the commission does the designating.
They do.
And right, in consultation with the director.
Yes.
So that makes, I guess it makes some sense. It's an interesting idea. My assumption is we actually may have to pay some of these hearing examiners to do this, but so that's another matter. It's a little bit like an administrative law judge that we use for other things that we're dealing with.
Chair Yang, Councilmember Gordon, that's correct. But we also pay our commissioners who are panelists for any type of appeals or what have you.
Sure.
They get paid also. So yes, I mean, the hearing examiner would get paid as well.
Okay, well, interesting idea. Thanks for clarifying a little bit. Okay.
Any other person wants to finish up this presentation, or are we done with the presentation?
I can do that. So we realized that the changes to the ordinance are comprehensive. So we're happy to stand for any questions that you have on specific changes at this point. But this concludes our presentation.
All right. So this is Council President Johnson.
Thank you, Mr. Chair. I guess, so today the committee would approve the ordinance. It would go to the council in a cycle then, at the end of the cycle.
Chair Yang, Council President Johnson, that's correct.
Okay.
And could I ask me, is there a rush to pass this down? Is there a time issue with regards to this?
Maybe I could speak to that just a little bit. I know this is something that Councilmember Glidden has been working on for a long time, and I know that it was her hopes and aspirations to get this completed before her term ended. And that's the sense of rush that I feel, and that might be that other people are working. And we've been working hard on this for a while, and that's my sense of urgency.
Council President Johnson?
Then, Mr. Chair, I would move this forward without recommendation, and I just would like to work with you on that language about the eliminating the ghetto words and still preserving some of the philosophical reasons behind that.
Council President Johnson, we haven't held the public hearing yet, no, that's okay. That's okay. And we're gonna open it up for a public hearing, but I will recognize you once we're done with the public hearing. Okay.
I'm sorry.
Okay. Thank you for your presentation. This is a public hearing, and so we will open up the public hearing now. Anyone want to speak on this issue?
Thank you. I am Amy Berquist. I live in Ward 3 at 700 South 2nd Street, and I serve on the Commission on Civil Rights as an attorney member, and I'm not speaking on behalf of the commission. I'm speaking only on my own behalf. And I, again, submitted written comments this morning, so I won't go into the details that are provided for you in writing in those written comments. I had prepared a resolution for the commission to consider regarding the department's proposed amendments to the Civil Rights Ordinance, but we had no quorum for our November meeting, so we were not able to discuss or consider the proposed amendments. There are two important changes that were initiated by the commission, and I urge the committee to approve and recommend approval to the full city council. First is section 141.20C, having to do with the attendance and quorum rules. You've already heard about that in previous discussions. The commission has been unable to function due to the ordinance's attendance and quorum requirements. We've had no quorum for 3 of our last 4 meetings. I think we're now down to 10 commissioners and we have a quorum of 9. So I'm not optimistic for our chances for our December meeting either. And we're the only such body in the city that has its attendance policy and quorum set by the ordinance. It would make more sense to defer to, especially for the attendance committee, to defer to the commission itself. The other change that came from the commission is 141.50Q on subpoena powers. So I'd encourage you to approve those proposed amendments. There are many other proposed amendments, and when I read them, when they were posted online, I felt caught off guard when they were posted for public comment. In the October 2017 meeting where we did have quorum, the department staff told us that all of the changes to the amendment were non-substantive. And we had a discussion of whether our 2 proposed amendments were in fact substantive. And we were told that Councilmember Glidden would support the revisions only if they were non-substantive. So I was surprised when I looked at the proposed amendments that there are at least some of the amendments are substantive and would affect the work of the commission. We had this discussion about the hearing examiner, and while I've missed 1 meeting this year, I don't remember any discussion of the hearing examiner, which would affect the workings of the commission. My written statement gives more details, increasing the number of attorneys required to serve on the 2 different hearing panels that the commission has, removing the authority of the commission to initiate its own complaints. It seems to, some of the revisions seem to change the jurisdiction of the ordinance and therefore change the jurisdiction of the commission. The point being that the commission should have been included in the process of coming up with these additional proposed amendments. Under the ordinance, the commission is responsible for advising the department on matters relating to the ordinance as they pertain to the commission's work. And we have had no opportunity to provide that advice. And I think it's always good to have another set of eyes on proposed amendments. And so what I'd ask the committee to do is defer consideration of these additional amendments until the commission has had a chance to provide its advice to the department and give its input and if necessary, issue a statement, because we simply haven't had the opportunity. But with respect to those 2 proposed amendments that we came up with, I urge you to go forward with those right away, just because we're being really, the work of the commission is being stifled by the attendance and quorum rules in the current ordinance. Thank you.
Thank you. Any other speakers?
Mr. Chair, committee members, Chuck Turchick, 2112 Portland. Again, I didn't anticipate commenting on these changes, but I should point out that despite the Minnesota Open Meeting Law, it's either Chapter 13 or Chapter 13D of the Minnesota statutes, the document indicating the amendments to this ordinance became available in this room at 2:38 p.m. today. They were not available at the beginning of the presentation from the Civil Rights Department, nor were they available in the binder outside the room. There might be a problem with the compliance with the Minnesota Open Meeting Law. Thank you.
Thank you. Anyone else want to make comments? Going once? Going twice? All right, we will close this public hearing. Thank you to all the folks who've spoken. Does staff have a response?
Chair Yang, Council President Johnson, council members. The changes of this ordinance were started in 2011. I know this because at the time, before I worked with the department, I happened to be the chair on the Civil Rights Commission for the S&P committee, the Standards and Procedures Committee. this ordinance change and feedback from the commission has been happening during that whole entire time. And we have taken feedback from the rotation of commission members since that time. We are now in 2017. The other thing I'd like to speak to is that there was reference to two requested amendments that were passed, requested amendments from the commission. If you look in the ordinance, we actually moved that forward. They asked for a change in the subpoena power. We took their language to work with the city attorney on that language. We took it, we put it within the proposed amendments. They asked that the attendance policy be taken out of the ordinance because it was not consistent with other boards and commissions and having an attendance policy in the ordinance. And in our proposed revisions, we took that out also. So those are there. When we have gone through this process that has been literally a 6-year process to get to this point, we have not, like I said, I'm going to reiterate again, we have not only talked to members of the commission, we have also talked and read and ran every change through the city attorney's office. And we have worked to do this in the most comprehensive way that we can. But at some point, we wanted to move this forward. It would be incredibly difficult to start an amendment of an entire title with every new commission that comes in. So we have taken that expertise of the commissioners over a period of time, and we have incorporated those changes and have gotten their feedback.
Michelle, I have a question for you. Within the ordinance, we just talked earlier about the mention of the word ghetto. How many times does that appear in the ordinance?
It appeared once in the ordinance at the very top as,
okay.
Yeah, just
okay.
once.
So one time, and let me just ask you, with regards to the replacement of that clause, and I believe the clause reads to eliminate existence and the development of any ghettos in the community. Mm-hmm. What's the replacement?
Well, as Chair Yang and committee members, as I was saying to Council President Johnson, we did not have a replacement, but we are more than happy to have a replacement statement as requested earlier.
Okay, and so I guess I'm trying to understand this. I mean, at some point we had this plain language charter amendment that essentially, was an update of our charter that, wasn't supposed to change any of the substance. I mean, updated the language, updated, several things. I mean, is that what this is, or are we doing things differently? I mean, is this really substantive in terms of a lot of changes that are happening, with regards to this update here?
No, Chair Yang, council members, no, these are plain language changes. We are trying to create, our main focus, and the reason why I put it number one, is that we are trying to create more clarity and readability of this ordinance. We've had a lot of compacted sections and paragraphs. We attempted to split them out. We had differing things throughout the ordinance, like the example that I used earlier. We try to put them in one cohesive place. It's extremely difficult to understand an ordinance. Even for someone who's an attorney, it's difficult to understand an ordinance. And our main goal here was to update the language and make it more, for lack of a better term, user-friendly.
Right. And I guess it's hard for me to understand that or accept that, just with the ghetto example. Mm-hmm. And, I'm indifferent with regards to, how we use it. But I mean, in the sense that like we had it and now it's completely gone from it. I mean, I think that's pretty substantive. Okay. And so I guess, I'm just trying to understand that part of it. But, I will leave it at that.
Okay.
Yeah. But thank you, though.
Thank you.
Council members, any other questions? Council President Johnson?
Mr. Chair, and perhaps the clerk can tell us, I know we have an abbreviated schedule for the final week of the council. Do we have a public safety meeting scheduled for that last week, or was it just the
Chair Yang,
just
Councilmember
CD and-
Johnson. No, we do not.
so it was just CD and
ZP.
CNP? Okay. Okay.
All right. Thank you.
Thank you.
Okay. Council President Johnson, did you want to renew your motion?
Yes, Mr. Chair, so I would move this forward without a recommendation and would request to work with staff to develop some language for replacement of that particular clause in the beginning. And then I guess perhaps work with staff to address some of the issues that Ms. Berquist brought up.
Okay.
And then it will come to us at Committee of the Whole for review, and then to the full council next Friday then.
Okay. Any discussion? I just want to point out that I think with regards to this, I mean, it's an update of the civil rights ordinance, but I mean, there are a few, if not a number of substantive changes here, and I think that we need to acknowledge that, and we need to figure out whether that's what we want. And I think, I mean, I'd rather do it right or have the council do it right than just do it in a rush. And so I'm going to support your motion to not have a recommendation for this. Any other comments? Councilmember Gordon?
I just want to acknowledge all the work that went into this. It is a 50-page, or that's with the strikeouts and the addition. So once it's all cleaned up, it'll maybe be 25, but maybe 30. So it is a lot to go through, and it's a lot to look at. And I recognize that there are some things that have more substance to them, and some of the changes. I think the hearing examiner instead of the panel was one of the changes that I was curious about, and it has some substance to it. Might make some sense. But I'm all right moving it forward without recommendation because I think it is a lot of material for us to review and to look at. And hopefully other council members will have a chance to look at it before it comes to committee of the whole, though. And maybe the author can help shepherd it through a little bit after the meeting today. It seems like it was a lot for people to take in and to figure out and to get behind with just this one meeting. So I'm very supportive of it also, and would be willing to help make sure that it gets past this term and try to help with that. So help with the changes and get it in good shape. But I'll also be here if we have to carry it through longer as well.
Councilmember Quincy?
Thank you. I'll be brief, Chairman. It was much to what Councilmember Gordon was saying. I wanted to recognize the work that has gone into this product over the years, and it followed our process. I mean, I know Council Vice President Glidden introduced it, I think, back in October, and then we set the public hearing date, and this is the first referral, but it's the ordinance language has been available publicly, and it's incumbent upon us to be reading those materials, especially when it's as substantive as this is. It's been worked on for so many years. I just wanted to acknowledge the work of Council Vice President, Councilmember Gordon, and the staff, both in the Civil Rights Department as well as the City Attorney's Office, that got it to this point. And absolutely supportive of the changes and excited to move it forward without recommendation with those final tweaks available to us. But I too hope that the council can take this action in these coming weeks. Thank you.
Okay. Any other comments, discussion? All right, seeing none, the motion before us is the motion to move this forward without recommendation. All those in favor, please say aye. Aye. Any opposed? Motion carries. Thank you. Now we have our second to last public hearing, and this is the amendments to Police Conduct Oversight Ordinance. It's passage of an ordinance amending Title 9, Chapter 172 of the Minneapolis Code of Ordinances related to fire and police protection. Police conduct oversight, clarifying the working relationship between civilian oversight, the police department, and city government. And our presenter today, please go ahead.
Good afternoon again, Chair Yang, Council President Johnson, committee members. My name is Imani Jafar. I'm the Director of the Office of Police Conduct Review, and I'm going to be presenting the proposed ordinance changes to the Office of Police Conduct Review 172.8, 172.9. We had a pretty robust discussion at the last Police Conduct Oversight Commission meeting about this ordinance. So both the commissioners and the police department representatives were there and have been engaged in conversation, I believe, with both myself and Councilmember Palmisano. So we'll start with just three major objectives here. To codify existing practices to make sure that the way that the Police Conduct Oversight Commission is operating both with our office and on their own is detailed in writing, to propose a commission expansion if appropriate, and to clarify the data access. So I'll briefly go through each one of these and then stand for questions. So the first is clarifying the research and study subject matter and process. As many of you have been aware, the research and study process has been something that's been very helpful to the entire city enterprise. Recently the commission engaged in domestic violence response protocol study. Mental health co-responder was born out of a commission study. So these are very important projects, and we felt that it was important to the public to make sure that that process is actually detailed in writing in the ordinance. So you will find that there are changes here that actually detail the research and study process and lay it out and how that interfaces with our office being the staff to complete that research and study process. And with that, to also explain the role of the OPCR legal analysts. How are they accessing the data? How are they using it in this reporting and going to the commission? And then likewise reporting it out to the city council, mayor. So all of that's codified in the changes. And then we thought it was very important to build in a function to have regular reporting to the city enterprises. Currently, we come in front of this committee annually to give a report, but we thought it would be a wonderful opportunity to really come in front of the council at the close of every one of these major studies so that we can figure out more ways to work together on these issues that touch not just the police department, but all of the residents of Minneapolis. The next thing is the commission expansion. As many of you are familiar with the commission, they do a lot of work. And right now they are sitting at a maximum of 7. But giving them the opportunity with the language reworded as it is here in the proposed amendments to have a minimum of 7 gives the opportunity for expansion if candidates come forward that are appropriate for expansion. I think right now with the several subcommittees they have, including policy and procedure and the audit committee, it would be a nice opportunity to have more members involved. It also mirrors the police conduct review panel appointments. There's a minimum there as well. So we'd like those two processes to be mirrors of one another. So recognizing the scope of the police conduct oversight commission, but also keeping them a workable size. One of the things we heard from them was, we don't want to be this giant commission, which I think all of us were in agreement with too, but the opportunity to maybe have a couple more members would be something that would really help them expand the scope of their work. And lastly is the data access. I think that you can see with a lot of trends in the city that many people are going towards having publicly available data. OPCR has had a publicly available data portal that has had thousands of hits on it. As that data access has grown, we wanted to make sure that was codified and we weren't just working under what would be a gentleman's agreement, that it's actually written down. And so here it clarifies what OPCR's access to the MPD databases would entail. OPCR has had this access since 2012, so it really makes sense at this point to codify it. Also, that data is being used in the research and study process, so making it very, very clear what that data is being accessed for and how it's being utilized is good not only for our office, but also for the police department so that we have that agreement formalized. And with that, my presentation is concluded, but I'll stand for any questions you may have.
Any questions? All right, seeing none, this is a public hearing, so I will open up the public hearing. Anyone who wishes to speak, if you can step forward, that'd be great.
Hi, my name again is Dave Picking, 4200 Cedar Avenue in Minneapolis. Yeah, I've had a little trouble looking at this ordinance to determine really what it's doing, so the presentation here has been of some help here. It seems like it's not a lot of substantive change, and as such, I'm not as concerned as I was in the beginning about the fact that, this wasn't out there in the public very much at all. Fortunately, it did come to the PCOC, so it sounds like it's a little bit better than the process there at the Civil Rights Commission. So I think there's a couple of things. The things that addresses I don't think are terribly substantive in terms of current practice, so I'm not too concerned about them. But there are some things that I think should be addressed in either this or some follow-up amendment to the PCOC ordinance. One thing is the choice of the chair of the PCOC. I know Councilmember Gordon brought this up a year ago, that it's unusual for the chair to be appointed by the mayor as opposed to being appointed by the commissioners. I think it would be much better if the chair were appointed by the commissioners. They're the ones who see the action of the chair on a daily, or monthly basis at least, and are much more familiar with the how the facilitation of the meetings is and other actions of the chair. I think also it gives more independence to the commission, something which I think is sorely needed. So that I would propose that that be elected. I'm also concerned, going back to the appointments, of the reappointment of the current chair, because she has been there for 4 years since the very beginning. I think in general it might be a good chance to rotate the chair. And to be perfectly honest, I think she's the least appropriate to be the chair of all the members that I've seen on the commission during this time, in terms of lack of independence and the conduct of the meetings. I could go further into that, but I don't want to do that in public. But I think that it's time to make that change. The other problem is the Police Conduct Oversight Commission. The word oversight, it has none. The ordinance could be interpreted in several ways, and the commission, including especially the chair, has interpreted it as having no function whatsoever in terms of oversight of the other half of the Office of Police Conduct Review, which handles the complaints. As the PCOC is required to conduct outreach, and that outreach has since the beginning recommended that people take their complaints to the Office of Police Conduct Review. And we now have a 5-year record of the Office of Police Conduct Review in which over 1,700 complaints have been received from the public. 7 officers have been disciplined. 4 of those have been simply written reprimands. I don't think hardly anybody would submit a complaint to that office if they knew that that was the record. It is time for the PCOC to make that record clear as part of their responsibility for oversight. I just have a couple minutes, so I guess I'll just say that I think there needs to be further work in this area to make the entire Office of Police Conduct Review a much more effective organization. Thank you.
Thank you. Any other speakers? Any other speakers? Okay, going once, twice. All right, we will close this public hearing. And with that, Councilmember Palmisano.
Thank you, Mr. Chair. Well, I guess first, just to respond to one of the comments in the public hearing, that's the first time that has come up through this ordinance and through the conversations that I've had, to have the commissioners elect their own chair. And actually, it strikes me as a great idea. But at this point, I would like to have a few additional conversations before we just quick make that change here at the end of the public hearing process. So I will hold off on suggesting that as an immediate amendment and consider bringing that forward if this does move forward to the December 8th meeting. But I just want to say, as a whole, what I've heard in the community is the need to have more oversight and accountability for police by the public. And these changes to this ordinance is one way to get that. It's certainly not the only way to get that. And I appreciate working directly with the people that are doing this work today to help give them more tools. This opens up more communication between the PCOC and City Council. It gives the PCOC explicit, unrestricted access to conduct and misconduct investigations. And it allows big reports on urgent issues like that of domestic violence that Ms. Jaffer had mentioned to come to council over this next year and to come more directly. So I'm the author of this, so of course I think all of these changes are good. I think this is a good incremental step in helping improve our civilian oversight. And I appreciate the conversations that I've had with others on this, and I am ready to submit it before you.
Councilmember Gordon.
Thank you. I support the work that's been done here and the changes too. I would support an amendment that would maybe loosen up the chair and vice chair's appointment from the mayor. I think that must have been a compromise that we did at the beginning, and then we actually kind of forgot about it. So I do remember bringing it up last time. I will note that there's at least one other advisory group. I think it's the Food Council, where there's co-chairs, and one of the chairs is also designated by the mayor. So it's not unheard of. But I'd be open to working on that change, and also I'd be willing to move it forward with recommendation, with the understanding that you're willing to explore that change between now and making a possible amendment.
Chair Yeager, if I could, to answer some of the questions here, I just had a conversation with Director Carbone, who said that was a holdover from the very first commissions. There was no commission to elect a chair, and that's from that very first time. So there's, no objection or problem to changing that just the very first time there was no commission. So I think that would be completely appropriate and fine to make that change.
Councilmember Gordon, I thought I might have heard a motion, but I'm wondering if you would defer to Councilmember Palmisano, who's the author, to make that motion before us, if that would be okay.
I wasn't trying to make the motion. I
Okay.
thought maybe she
That's
had
what I
made
thought
it
I heard.
already, but I
Okay.
think she gets to make it.
I
if she
wanted to
wants
clarify.
Yeah.
Okay, Councilmember Palmisano. Oh, Council President Johnson.
Mr. Chair, thank you. I just think before we would move to remove the mayor as the appointing authority, we should talk to the mayor too. So anyway, just
There's no motion with regards to that at this point. No. Yep. Councilmember Palmisano.
Thank you. I agree with the council president that I am very appreciative that that's kind of the genesis of how this started. And I'm open to the change, but there's still a few conversations I'd like to have with others before I'm ready to make that change. This has been a very long process, and it's been very carefully considered, and the wording in this is very specific to allow and give permission for additional access. So I just want to make sure that it makes sense to a lot of different groups, and so I seek to move the ordinance now and not currently with any changes than what's before you today.
Any discussion? All right, no questions on discussion on item number 8, which is the amendments to the police conduct oversight ordinance. Okay, well, seeing no one who wants to make comments with regards to this, all those in favor, please say aye. Aye. Any opposed? Okay, the motion carries. All right, and we are now here for our last public hearing, and this is a public hearing with regards to unmanned aircraft ordinance. And so presenting before us, I see a member from Public Works, so please, Mr. Borges.
Good afternoon, Chair Yang and committee members. John Wirchis, Director of Traffic and Parking Services with the Public Works Department.
You seem to be a little bit out of place with
I
the
am
committees.
out of place, but let me give you some context with them. Well, thank you. I'm here speaking on behalf of a broad group of departments who have been engaged and have provided input on this. Not only Public Works, Reg Services, Police Department, CPED has been involved, and the City Attorney's Office has been involved as well. So we've got a broad look at this stage. We are moving forward with a proposed ordinance, a new section of ordinance to Chapter 385 related to restricting certain aspects of unmanned aircraft. And so with that, I would note that this is a fairly short ordinance. To start off, we're not intending to get into a lot of weeds at this stage. in conversations with those other departments, we view that there's more conversation that still is needed in that regards when we talk about citywide implementation of an ordinance related to unmanned aircrafts. Before I get started, unmanned aircrafts can also be known as drones for folks, so wanted to be clear on that. The ordinance that's being proposed is really put together in two sections. The first section is definitions about what unmanned aircraft and those items are and a person is, but I wanted to take 2 seconds and talk about the definition related to a special event zone, because I think that's what's important to discuss today. On the overhead is a map that kind of, and on the online is a map that indicates the special event zone that we're defining in this ordinance. To give you some perspective, it's difficult to read and understand the location. So we have downtown and we have a shaded area around downtown. On the southerly side of the drawing is Franklin Avenue going east and west. Up on the east side is the city limits with St. Paul. We then cut across approximately on Elm Street here, go up 8th Street, jump over on Spring Street and 8th Avenue, which then comes into Plymouth Avenue, come down a line approximately Van White, and then jog over a little bit on 394 back to Humboldt and to close the loop on Franklin. So it's an area larger than the downtown area to ensure we've got proper coverage and ability to restrict in that zone. And I'll come back to that when I talk about the restrictions in a moment. So that's what the definitions are intended to touch upon in the ordinance. The second piece of the ordinance is requirements. There are basically 6 of them. The first 2 are really about following federal statutes and FAA rules. If you're flying a drone, you need to follow those. The second one is related to state statutes. I'm not aware of all the statutes that the state has weighed in on that, but in that regards, there may be those out there. The third one gets to this special event zone. This special event zone would be in place during 3 intended time periods. The first intended time period would be for the Super Bowl, starting basically mid-January and going to February 5th, right after the Super Bowl, so approximately 3 weeks. It then would shut off again, this special event zone, and it would turn back on later this year in July, or in 2018, excuse me, in July, and go for a week during the X Games. It would then turn off again, and then it would come back in 2019 for the Final Four and turn on again in April 3rd to April 10th of 2019. That's how we have set up this special event zone and how it's laid out in this Section 3. The fourth item here is really about, I'll say, proper care and safety related elements about not operating your unmanned aircraft in a heedless or disregard or careless way for not only human interaction, but also property in that context. And lastly, number 5 is related to operating the drone within 25 feet of someone without their permission. And we thought that would be a proper requirement. And then the last one refers to the penalties of violating these ordinances, and that refers to Section 130 or 1.3 of the code, which makes it a misdemeanor in this regard. So with that, Mr. Chair and council members, that are my kind of presentation relative to this new ordinance.
Any questions? Councilmember Quincy?
Thank you very much, Mr. Wirtjes. I have a couple quick ones. One is on the issue of enforcement. How would this be enforced, and what would be the penalties associated with it? Forgive me, I'm not as well versed in this area yet. And the other question I have is St. Paul doing a similar or ordinance in parallel? Have they defined a different zone that would affect? I'm thinking about Super Bowl activities as well as their, the crushed ice event and everything at the soccer stadium that will be coming up, or in the baseball stadium that they have, or XL, et cetera.
Yeah. Mr. Chair and Councilmember Quincy, The penalties, as I best understand, Corey had to leave me for another meeting, and I'm not sure I completely understand that, but I think the penalties will be enforced through typical misdemeanor applications. I think that's maybe upwards of, I think Corey said $1,000 to $1,100 of a fine at that regards. I think that's the level of penalty. That's, if there are further questions, I can get some answers back for you from the attorney's office and others. But
I just wanted to make sure that there was an enforcement mechanism, and so people couldn't, we could say there's a zone, but if there's no penalty for that, I wanted to make sure there was. And then any comment on what the other jurisdictions are doing?
Mr. Councilmember Quincy, I'm not aware of St. Paul having any special provisions for their particular events. I do know that federal FAA rules have encompassing criteria about not flying an unmanned aircraft over large crowds of events and large event structures. For example, target field and stadiums and ball fields are kind of covered in the FAA rules. Part of our concern of bringing forward a zone here is to make it a little bit clearer about where we don't want you to fly and when we don't want you to fly. Takes a lot of effort maybe to read through all of those FAA rules in order for a common citizen to want to understand where they can and can't, and they just want a nice view of the stadium and they don't know that they're in violation of something. And so I think this was our approach. So I don't know what, the long answer to your question, I don't know what St. Paul's doing.
Council President Johnson.
Thank you, Mr. Chair. Actually, Mr. Richards was just reading somebody was charged federally on one of those kinds of things. I can't remember where it was, but the practicality of it, how would the police track somebody that was flying a drone? I mean, you know what I mean? I see it go over. It's a great idea, but I just don't know how it works.
Mr. Chair and Council President Johnson, there are some specific words here in Section 3, and I'm just going to read them for you. No person shall use, assist, or facilitate the use of the aircraft for takeoffs and landings from or to any land, waterways, or water bodies. Okay? So basically what we're doing with this ordinance is not regulating the flying, because FAA folks will say that's their jurisdiction. What we're regulating here is the land use, i.e., you can't have an airport in your backyard to take off and land. And that's our ability to see it and to be able to enforce it. We can see you take off and land. Now the device is up in the air. It's got to come down somewhere a little bit. And so if we can, in this zone, know to basically say, don't take off and land in this zone, and it's difficult to fly into the zone, it kind of preserves the area and the intention of preserving safety for the large crowds of people that we are intending to have. That's our basic premise behind this. We're hoping it will work. We think it will work.
Council President Johnson? Okay. Councilmember Gordon.
Except that you can, if you're outside of the zone or on any of those other events, you can land and take off with your drone on property and waterways, right? What you just read only applies to the zone on those specified dates.
That, Mr. Chair and Councilmember Gordon, that is correct. The takeoff and landing restriction is tied to the dates and the zone specifically in Section 3.
So
the other provisions,
other dates and other parts of the year and parts of the city, I mean, you can be landing and taking off your drone. It seems like almost anywhere you want, except within 25 feet of any individual person or property without their permission. So you could do this in your own yard, or you could do it in a park that's empty, I suppose. So I'm a little bit curious about where we're expecting the problems to come from with the drones and why we picked 25 feet. Are there going to be drone delivery systems going on that we're going to be regulating here, or is this all about hobbies? Or do we think there's going to be surveillance drones that people are going to hire to be used? And is this going to work? So why are we regulating them? And what do we think the risks are? And as 25 feet, why is that the right distance?
Sure. Mr. Chair and Councilmember Gordon, I'm going to go back to the beginning of your questions. You are correct. Section 3 is going to turn on and turn off only during those event periods. The other sections 1, 2, 4, and 5, and 6 all apply throughout the time. So follow the federal rules, follow the state statutes, fly your drone carefully, and heed other buildings and people. And we think a reasonable distance from another person so as not to induce fear or concern is 25 feet. And that's how we came up with that. Other jurisdictions, we've looked at some jurisdictions. We weren't comfortable going much further than follow the appropriate rules and follow some basic distance requirements, this 25 feet, in order to say we're being judicious with how we're doing this. There may be at a later date a need to come back and change these ordinances to update them because of some new unique circumstances that are now occurring. We didn't want to necessarily chase a problem that we don't have yet. And in this case, we wanted to ensure safety around these special events and then have some basic premises around how you operate your drone, which is follow the rules and be careful.
So is 25 feet something that's really common? Or did we just pick it because of something we felt? Did we measure? So we can have drones going down the center of the street and probably stopping in front of our houses because is it the property line? Yeah, that might be.
Mr. Chair and Councilmember Gordon, I'll have to consult with Corey on how much research was put into the 25 feet. I cannot say here today. And
it sounds okay. I mean, I'm sure that I'll support this, and I'm sure Councilmember Reich wants to move it forward. I know it's his ordinance. So.
Councilmember Reich.
Yeah, my intention was to have this move forward. And then in terms of enforcement, I did see a YouTube video where some city, I think in the Netherlands, had employed trained raptors, large raptor birds, in the enforcement of their policies. So just a helpful suggestion as we try to muddle through this new policy. And of course, since I saw it on the internet, it must be true.
Councilmember Reich, I think those things were extinct thousands of years ago.
No, the birds of prey.
Oh.
Isn't that a term? What are they called? Yeah, that's a raptor.
Okay.
Yeah, so an eagle, an owl.
Oh, got it.
An aggressive falcon, that sort of thing.
Got it. Okay. So, Councilmember Reich, do you want to move your item forward?
I do. I wish to move it forward.
Okay. Thank you. Any discussion on this? Councilmember Reich, if I may, I just have a couple of questions with regards to this to Mr. Wirtjes here. Well, let me start by just seeking advice from the city attorney with regards to this. You know, a typical misdemeanor is 90 days in jail or about $1,000 fine. Is that fairly accurate?
Yes.
Okay.
It is, council member.
Okay.
And I believe the enforcement provision, I believe, refers to, I think, the administrative citation process, more focusing on financial penalties than anything else.
Okay.
Which really is what gets folks' attention more than
jail time.
Yeah.
Okay. All right, Mr. Wirtjes. You know, I just wanted to focus on the requirements piece, 3A, B, and C, and those are specific to the Super Bowl, X Games, and the Final Four. And I mean, it just seems kind of awkward because once we get to those times, I mean, that just becomes irrelevant once we pass those times. And wondering, I mean, was this the best way we could approach this, or are we going to basically create a new list, post 2019, the Final Four, and essentially just plug it in every single time, without changing the ordinance, but specifically just changing those dates for special events? Or how are we going to manage that? Just because it seems awkward to do it like this.
Yeah, Chair Yang, I would agree there's a little bit of awkwardness about it. Other cities have taken a variety of different approaches. We weren't sure that we were ready to jump on board with any of those, especially given the conversations that we've had with the FAA and trying to understand what they regulate and what cities can regulate or should regulate. And so at this stage, this was sort of the best way we could deal with these special events, with the understanding that we have some more work to do to kind of come back and say, what would we do in the future, not only for another special event if we need to, but what should we do citywide to deal with any regulations? And yes, we've got some examples of circumstances where unmanned aircraft have caused problems, but we need to understand that a little bit more on our part to bring something forward.
And, with regards to this ordinance, do we have a definition for special events? And I asked just because, what's the criteria? I mean, if we have, let's say, the World Series here in Minneapolis, I mean, is that, something that we should just put right on there really quickly? Or, let's say if we make a playoff championship or we make a playoff, I mean, are those things a part of it too? Or where are we on that?
No, Mr. Chair, I think there may be, if we do nothing more than this, there could always be an opportunity to turn this back on for some future event if something new comes along. It might need to also be tweaked because the event is being held at some place outside of the zone. And so there's always that possibility. At this stage. I don't know what they would be and when they would be, so it's a little difficult to gauge that. But I think that's an opportunity in the future.
Okay, and one last question with regards to this. With regards to these special events, I mean, how are we going to let the public know that, it's a special event? You can't fly your drone, in the special events area. I mean, what's our best way of doing the outreach, or what are you all thinking at this point?
Yeah, Chair Yang, we think we've got a good opportunity here with Super Bowl and a lot of media on that to kind of get the word out. And that's one of the reasons the zone that we picked was, as I'll say, square as possible that we could make it, so we could give people some basic, easy understanding boundaries without having to say, there's this radius around that and this radius around that, wanting to be too cute with some line jagging around the city. And so we think we've got that. I think we'll also realize that we'll have another uptick with X Games and with Final Four to kind of re-emphasize and get the word out. And so our communications team is understanding that and has been ready to kind of help us with that effort to get the word out.
Okay. Any other questions or comments with regards to the motion before us? Okay. Seeing none, I guess
Mr. Chair,
yes.
Do we need to have a public hearing?
Yes, we do.
Okay.
Yeah, thank you. All right, it's been a long meeting. Thank you. At this point, I will open up the public hearing. Anyone who wants to speak with regards to the unmanned aircraft ordinance, please come forward. The motion, though, has been made, and we will just suspend the motion until we get to appropriate time. Mr. Turchik, I apologize.
Chuck Turchik, Mr. Chair, committee members, Chuck Turchik, 2112 Portland. Again, I had no intention of testifying on this ordinance, but the term unmanned aircraft appears through in unmanned. Is it aircraft? Is that what the term appears in the ordinance? And there's a definition of the term as well. It seems to me I have heard a non-sexist term that has been used as a substitute for that. And I would recommend you researching that and substituting that term throughout the ordinance. Thank you.
I imagine the term was drone. Was it some other term? Please.
I guess I'm catching Mr. Church's enthusiasm for making statements for which he hadn't come prepared. With regard to the point that Chair Yang was making about baseball events, my suspicion is we wouldn't have sufficient notice for the council to adopt these measures because we wouldn't know whether the Twins would be in the playoffs or would be in the World Series until I forget, it's a week before the event. So I would encourage consideration of incorporating some sort of generic provisions that could be used going forward so that you're not in a time crunch and can't implement these procedures for other events as they arise.
Yep. Any other community members who have public comments? If you want to step forward. All right. Going once, going twice. Okay, we will close the public hearing, and my apologies for that. Mr. Wurges?
Chair Yang and committee members, in reference to the most specific or last comment made, current FAA rules do restrict flying over, stadiums, ballparks, et cetera. It's pretty generic in that regard. And so any twins, hopefully successful endeavor, will already have that in place according to federal statutes or regulations. So.
Councilmember Wright, do you want to renew your motion?
Thank you, Mr. Chair. I move it as submitted.
Okay. Any discussion? All right, seeing none, all those in favor, please say aye.
Aye.
Aye. Any opposed? Motion carries. And that was long, but thank you all for being here. We are done with our business for today, and so we will adjourn this meeting. Thank you.